first place. I'm pleased to be joined by my colleagues at this table who have worked tirelessly to develop and advocate for legislation that improves lives. Dr. Wendy Lane will provide a brief overview of child sexual abuse in Maryland and the impact of child sexual abuse on children, all grounded in the science of the developing brain and years of experience as a pediatrician and epidemiologist. Catherine Robb is the Executive Director of Child U.S. Advocacy, who has devoted her career to working with state legislators across the country to pass child protection legislation. She will give you a framework for what's working across the country and why this legislation is sound public policy. Kathy Hoke, whom many of you know and trust for her legal counsel to this body, will speak to the nuances of the legislation, the constitutionality, and the need for this committee to examine the history of this legislation and make their intentions clear. Child sexual abuse directly impacts a victim's life at the time trauma occurs, and often for years, even decades after the abuse has ended. This extended trauma impacts the adult survivors' relationships and has generational impacts. Brain science teaches us about the impacts of trauma on children. We know that victims have increased rates of physical and mental health issues. We know that victims have increased risks for interpersonal struggles and risk-taking behavior. Generational trauma impacts victims, their children, and grandchildren. The often undiscussed ripple effect of child sexual abuse is its impact on all our lives. Victims of child sexual abuse, both as children and later as adults, have increased rates of interaction with many public services, including law enforcement. This includes investigating cases of child sexual abuse, but also responding to interpersonal violence and responding to criminal behavior triggered by trauma. Education systems, including increased need for counseling services, school resource officers, and IEP for students processing their trauma in real time. Healthcare for training ER professionals and creating safe units to addressing negative health outcomes triggered by the physiological impacts of child sexual abuse on the brain and body. Substance abuse and mental health services, including the cost of treatment and the legal, employment, housing, family, and relational issues substance abuse brings. Social services, from the training providers in the long-term impacts of abuse to disability services, housing support, and long-term care facilities. Workforce loss of productivity in the workplace impacts the economic drivers we depend on to maintain our state. There is one aspect of child sexual abuse that this bill uniquely targets: institutional betrayal. All too often, child sexual abuse occurs inside the very institutions where kids count on adults to protect them: our schools, houses of worship, sports teams, and community clubs. Psychologist Jennifer Freyd first developed the concept of institutional betrayal to describe how institutions perpetuate or look the other way on harm done to individuals who depend on them. When a child is sexually abused within the context of a trusted institution, such as a school, a church, the way the institution responds is predictive of how the child will fare. The institution's response has the power to exacerbate or mitigate the harm of the original trauma. When institutions respond with denial, silencing, shaming, or ostracizing the individual, the child, and later the adult, experiences this breach of trust as a profound betrayal that research shows causes psychological and even physical harm. Even inaction compounds the trauma, tantamount to invalidating what the victim has experienced. Institutions that have the power to give voice and redress to victims of child sexual abuse and or look the other way and do nothing compound victims' trauma. Some institutions, including some opponents to this accountability legislation, are guilty of a very aggressive form of betrayal known as institutional DARVO. DARVO stands for deny, attack, and reverse victim and offender. It refers to a reaction perpetrators particularly sexual offenders or institutions that protect perpetrators and themselves may display in response to being held accountable. The perpetrator institution may deny the behavior, attack the individual doing the confronting, and reverse the roles of victim and offender, such that the perpetrator institution assumes the victim role and turns the true victim or the whistleblower into an alleged offender. DARVO not only exacerbates the original harm, it also inflicts another entirely separate one, often in ways that are ongoing in the victim's life. We know child sexual abuse happens in every community. It's time we started listening to victims. Abuse thrives on denial, secrecy, and a lack of accountability. We can only stop it if we listen, acknowledge it, and address it. For years, I have worked as an advocate alongside individual survivors, community groups, nonprofit organizations, and businesses in pushing this legislation. We are often met with well-intended lawmakers who are concerned about the impact of this legislation will have on survivors and their families. Let me be clear with you, because survivors have been clear with me about what they want from this body. Protect our children from sexual abuse. Hold abusers and those who protect them accountable. Give survivors the opportunity for their day in court. Thank you.
Good afternoon, Chairman Smith and members of the committee. My name is Wendy Lane. I am chair of the State Council on Child Abuse and Neglect, and I am also chair of the Child Maltreatment and Foster Care Committee for the Maryland chapter of the American Academy of Pediatrics. I'm going to be talking today about how common child sexual abuse is, share some data, some national and state data with you. I'll talk briefly about the physiologic effects of child sexual abuse, the health effects, and then I will end with talking a little bit about why kids don't disclose. So how common is child sexual abuse? Well, we know from national data, and this is only data on cases that get reported and investigated and determine that abuse happened. In the U.S., about 1 out of every 1,000 children have been reported for sexual abuse and determined that abuse have happened each year. In Maryland, that number is higher. It's 1.5 children per every 1,000 children in the U.S. In Maryland. We know from surveys of survivors that approximately 19% of all women and 9% of all men were abused as children. So we all encounter stress every day in our lives. Those of you on the committee, hopefully the stress of doing your work is positive or tolerable. But many events like child sexual abuse can lead to something called toxic stress. And that is the prolonged activation of stress response systems that often occur when somebody does not have the resources to buffer that stress. And those could be interpersonal resources, it could be resources of the people around them, many reasons. So what happens when somebody experiences toxic stress? So our bodies are designed to respond to stress through two different systems, the HPA axis and the SAM axis, and I'll talk about those in just a minute. You may be familiar with the sympathetic adrenal medullary system. It's a lot of language, but basically this is the physiologic system that when your body is stressed causes the release of epinephrine or adrenaline and norepinephrine, and that leads to either a fight or flight response and sometimes a freeze response where you just don't know what to do. but it's getting you ready to either do battle or to escape what's going on. A second response system is the hypothalamic adrenal medullary system. And that's the one that responds to stress through the secretion of cortisol. So normally, both of these systems kind of return to normal. Those hormone levels, the release goes back to normal when the stress goes away. But when the stress is ongoing, our body isn't able to tolerate that. Basic science has shown that our body can be overwhelmed by those hormones, and that can lead to issues like chronic inflammation and problems with immune system dysfunction. So even one episode of child sexual abuse can be a chronic stressor when there's no mechanism for coping with that experience. And so research has, multiple studies in the literature have shown that there's a strong overall association between sexual abuse and poor overall health, higher rates of chronic illness, greater functional limitation. And we know from studies also that this association can persist even after controlling for mental health concerns like depression. We know from the literature, from research, that individuals who have been sexually abused have 3.5 times higher risk for having a mental health disorder. And that may include depression, anxiety, bipolar disorder, psychosis, suicidal ideation, and obsessive compulsive disorder. We also know that sexual abuse increases the risk of having a substance use disorder, either during the teenage years or later in life. And that may include, studies have shown that that increases the risk of polysubstance abuse in teen girls. It increases the risk of opioid misuse during pregnancy. And it's associated with alcohol misuse among men who have sex with men. Sexual abuse has also been strongly associated with eating disorders. And the more incidents of sexual abuse that an individual experiences, the higher the likelihood that an individual is to have a binge eating disorder, purging issues, or over-concern about their weight. Children who are sexually abused have much higher rates of teen pregnancy than non-abused children. Children who are sexually abused have higher rates of victimization as they grow older. They have higher rates of sexual assault. They have higher rates of being victims of domestic violence. And they have higher rates of self-harm behavior. And all of this leads to higher healthcare costs. So individuals who have been sexually abused are likely to have higher healthcare costs over their lifetime. They're likely to have more doctor visits. They need more surgical procedures, and they have more hospitalizations than those who have not been sexually abused. So why don't individuals disclose? Why don't kids and teens talk about what's happened? Let me talk about this as a pediatrician from a developmental standpoint. So in infancy and toddlerhood, a child may not realize what's happening to them. They don't know that what's going on is wrong, and they also generally don't have the words to describe what's happening. So imagine yourself as a preschooler, a 3-year-old, a 4-year-old, and you're in preschool and your caregiver or preschool teacher tells you that what's happening is a special secret between the two of you and that nobody else should know about that secret. Imagine that you're an 8-year-old. You're starting to get the sense that what the abuser is doing to you is wrong. Okay? But Your abuser tells you that it's your fault, that what you did, that your behavior made this happen. And you believe him. You're ashamed, so you don't tell anybody. Now imagine that you're a teenager. Imagine yourself a preteen. Imagine yourself that you're a 12-year-old. Your mother needs help from your abuser to pay the rent or to pay for food. He threatens you that if you tell, nobody will believe you. And he tells you that they will take you away from your family. He tells you that if you continue to go along, then he won't go ahead and abuse your sister. Okay. So now imagine yourself at 15. Your teacher tells you how special you are, how talented you are, how beautiful you are. And he makes you feel special. And you feel pretty grown up, and you believe what he says. You can't even imagine that he's taking advantage of you because you're mature and you can make your own choices. So all of these scenarios are things that I have heard as a pediatrician taking care of kids who have been sexually abused. And some of these kids are able to come forward during their childhood, but many are never able to come forward during their childhood. And that's what we're talking about today. So thank you. And I will turn it over to Catherine Robb.
I think we need a mic for taller people. Chairman Smith and members of this committee, thank you so much for allowing me to present today on this very, very important issue. My name is Catherine Robb. I am the Executive Director of Child U.S. Advocacy, and I do this work all over the country, including at the federal level on the Hill. Worked with quite a few folks there. I would like to sort of segue from what Wendy just spoke about and delayed disclosure. What we know is that presently the average age is about age 52 when survivors are fully able to come forward. But we're now focusing on some recent data where it really is between age 50 and 70. Like that's the time where most people come forward. Sadly, many people never come forward. They take this to their death. I have worked with survivors all over the country, and sadly, I've been to quite a few funerals where survivors just couldn't take it anymore and ended their own life. So again, the average age is 50 to 70, average that span, and the average age is 52, but sadly, many never are able to come forward. I often ask this question when I testify, and the question is this: why should sexual predators and the institutions that conceal them be protected by the passage of time, yet survivors suffer in perpetuity? I think it's an important question to consider for policymakers, for lawmakers. I think it's an important question. And, you know, the other question I get is, why does it take survivors so long to speak, to come forward? Why didn't you tell anyone, right? That type of thing. And I answer this way, as you can see on the slide, because the abusers and those careless and perhaps reckless institutions bury children alive. And they do so in a tomb of heavy silence and shame and deep, deep trauma that was just shared with this committee. It takes years to break free of that. And I know this because I am one of those survivors. I was abused as a little girl for about 8 years by someone I knew and trusted and at one time loved. So when I come forward to speak, I'm not just speaking as an attorney, as an expert on this, but also as a survivor. And honestly, to all of those here that are parents, as a mother of 5 beautiful children. I speak based on common sense and justice and what we all understand to be right as parents and what we teach our children is right. The best data that we can find right now, and this is based not just on CDC or FBI, this is research data done at high institutions across the country, and that is about 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. That number is astonishing. That means that 13.5% of all children, and these are adults that come forward, will suffer from child sexual abuse as children. Statute of limitation reform, especially revival legislation, which is what we're talking about here, really serves 3 public policy purposes. I think one of the most important things is that it identifies hidden sexual predators that are out there, right? Because people can come forward and speak openly about that. It punishes bad actors, and it shifts the cost. And as lawmakers, you should be concerned about this. It shifts the cost away from taxpayers to the bad guys, where it belongs. And finally, it educates the public, right? And, about the prevalence of this serious societal issue, about the impact of abuse. It educates the public, and they have a right to know. I think parents have a right to know. I think grandparents have a right to know. It educates the public, and that's a really important public policy. You are likely going to hear in this body, and perhaps outside this body, that tort law, by its very nature, deals with terrible accidents, maybe catastrophic type of accidents as well, right? But what I would say to you, and what I would say to them, that these are not typical torts. These are not accidents, right? We are talking, and let's be clear, about the rape, sodomy, and sexual assault of our children. These are not slip and fall cases. These are not breach of contract cases. These are in a very, very different category. And the law should reflect that difference, right? We should make those changes. I understand, as an attorney, as an American citizen, I believe in due process, but all of our laws have exceptions. And there are exceptions on the exceptions. And those exceptions are based on common sense and reason and justice and sound public policy. And that's where this body comes in. You may also hear that they have a purpose, right? To prevent stale claims, to have people come forward at a reasonable time, to have the best evidence be available. I think that makes sense, but not for these sorts of claims. So I ask, should the law and public policy reward sexual abusers and other bad actors for the very silence they cause in their victims? Do we let them benefit from the silence and frozen fear that they created in their victims? That can't be good public policy. It just can't be good public policy. And you may also hear the sky is falling types of statements like, the courts are going to be overwhelmed, they're going to be flooded. Nope. We have seen this across the country. If you look at the data on this chart, and we look at the population in each of these states, something like New York, which is almost 20 million people, right? If you look at these numbers, the courts weren't flooded. The courts dealt with this issue. They're still dealing with this issue. A little under 11,000 cases were filed in New York. If you looked at California, the same would be true, and only a little over 1,100 cases were filed there in a very populous state. You may also hear, we don't need to change the civil system for child sexual abuse because we have these criminal laws and this criminal system. Sadly, no. The majority of sexual abuse claims never get prosecuted, right? There are limitations to our criminal statutes. There we go. Okay. I don't expect everyone to read through all of this, but I just want to point out a few. First of all, as we all know, the burden of proof is so much higher in a criminal case, right? So if state's attorneys don't believe that they can prove a case, they're not going to take it. So there's going to be no criminal prosecution. Fewer than 20% of sex crimes, this is one study, and I can share the data if anyone wants the citation for this. Fewer than 20% of sexual crimes are referred to prosecution, and only a half result in conviction. Okay? That is not protecting our children. That is not having justice for survivors. The victims have very little voice in the criminal system. They're witnesses. They have very little power. State's attorneys may be overwhelmed, may not have enough resources to move forward on these. There's also limited discovery in the criminal end. We need to have discovery to disclose these hidden sexual predators and to disclose institutions that are not having safe policy, procedure, responses to this problem. Criminal statute of limitations cannot be revived. The United States Constitution has already determined this. So we must look to our civil statutes to allow these victims to come forward and speak when they are able to do so. You may also hear, Maryland will be an outlier. Few states are doing this. We don't want to be different than everyone else. No, far, far from the truth. Right now, we have 27 jurisdictions that have passed revival legislation. We have 17 that have completely eliminated the statute of limitations. We have many states right now that are moving forward on new legislation. Now, you might also hear that some of those states limited the action just to the perpetrator. That's true. It was Georgia, it was Rhode Island, and it was Massachusetts. Guess what? Those states are introducing legislation this year to correct that problem, right? It was just a one-step response to the problem, okay? So this is a national movement. If you look here at this timeline, right, you can see how states are saying, okay, we see this, we get it, and they're responding accordingly. Again, we have 10 states that have introduced legislation already. You can look those up. And we have 7 other states that are introducing. I know this just because I'm working with those lawmakers in those states. This is a civil rights movement for children. And sadly, presently, Maryland is in the back of the class in that movement. There's also been a fair amount of federal SOL reform legislation. We worked very closely in my organization with Senator Dick Durbin to pass Senate Bill 3103, eliminating the statute of limitations for those claims. We also worked very closely with lawmakers to pass the Respect for Child Survivors Act, and that's basically educating the FBI. This was in response to Larry Nassar, by the way, to educate the FBI in how that they interview victims, right? So there's a ton of legislation. Here's a little bit more on Senator Durbin's bill. And by the way, if I can just say this, is if we have someone like Senator Dick Durbin, who's the chairperson of one of the most powerful committees on the Hill, and he's talking to the press about things like delayed disclosure and the need to change our statute of limitations, right? They're getting it. This is a movement that Maryland needs to get behind. We have a couple of bills presently that will incentivize states to change their statute of limitations by giving them more funding. through different types. One is the STOP program, and the other is the grant program. And I have some of these on this slide. Congressional members are also looking at reforming Title IX because there are problems there, and there are tremendous problems in Chapter 11 filing a bankruptcy. The biggest problem is that it was never passed by Congress in 1972 to be a clearinghouse for child sexual abuse claims, right? This was about businesses that were really struggling, right, and fell on bad luck and needed some help to reorganize, right? So we are working with folks in Congress on these bills as well, both bankruptcy and Title IX. We are working very closely with Congressman Jamie Raskin on some of these bills as well. So this is what Congress is concerned about. This is what the nation is feeling concerned about. I mean, look it. You can't turn on the news any given time or, look at a newspaper and not see another story about kids that are sexually assaulted. It is at epidemic proportions, and lawmakers must respond. I just want to speak just briefly because, as we know, there's conversations around caps, and I just want to say this. There is no jurisdiction that has passed revival legislation with a cap. None. Zero. And although we need to work with each other to pass sound legislation, I just want to point out just how inherently unfair this is, quite simply. And if you look at this, little chart we did, an image, if you have a boy on a soccer team who is injured because the coach failed to respond in a reasonable way at a reasonable time and breached his duty and did all that and caused harm to this kid, there would be no caps, right? This is generally on caps is what I'm talking about. But if we have the same coach, same team, different boy, and he is sexually assaulted by that same coach, there would be caps. So generally speaking, it's bad optics, and we do frown upon caps as not really serving justice or being fair. I would just like to share, this is based on a little over 214,000 cases that ended in either a verdict or a settlement. And the average overall was a little over 3.2 million. The average verdict was obviously much higher, and the average child sexual abuse settlement was a little over $1.2 million. Bad actors, institutions that fail children should bear the cost of this, not taxpayers. And again, as I said earlier, of these 27 states that passed revival legislation, 0 have had caps on damages. Just quickly on bankruptcy, there is a lot of conversation about bankruptcy. First of all, Chapter 11 is a voluntary process, as many of you in this body may know. There are lots of problems with this process. It saves institutions. It doesn't save survivors. It doesn't help them, right? They get pennies on the dollar. They don't get any discovery. They don't have any voice at all, right? This is why Congress is working on this, right? So although you'll hear, people will go bankrupt, well, organizations and institutions will go bankrupt. It's voluntary. And many of them are not insolvent, at least based on the way we understand what insolvency means, right? So again, bad actors are benefited by this process. It is voluntary. They get a new day, right? They get to reorganize. They still run their businesses. They still have their services. So those alarms and the sky is falling types of things just don't have any weight. Victims really struggle through this process. There's a lack of accountability, very little discovery. There's a heavy use of protective orders in the bankruptcy courts, which seal documents. And what that means is it seals information about known sexual predators that are out there. So this really benefits institutions. It doesn't benefit survivors. And it certainly doesn't benefit society. That's all I have. Thank you so much.
Since the so-called statute of repose terminology was discovered in the uncodified section of the code in 2019, legislators and proponents of justice for survivors of child sexual abuse have asked, how did the statute of repose language get into HB 642 and SB 505 in 2017? In other words, where did this language originate? And perhaps more importantly, did legislators understand what a statute of repose was and intend permanent immunity for sexual abusers and those that protect them? To date, it is my understanding that no legislator that Chairman Wilson has spoken to has admitted to knowing the origins of the so-called statute of repose, nor has any legislator, other than potentially the vice chair of the Judiciary Committee in 2017, former Delegate Dumais, admitted intending to give permanent immunity to sexual abusers or those that protect them. We'd like to share the facts as we know them about the history of 2017 and 2019 bills and the origins of the statute of repose language. In 2017, three child sexual abuse bills were introduced. HB 642 by Delegate Wilson, SB 505 by Senator Kelly, and SB 585 by Senator Young. All three bills applied prospectively at the time and not retroactively to claims that already had been barred. SB 505 and SB 585 got off to a rocky start at the Senate Judicial Proceedings hearing when a controversy broke out regarding how Senator Kelly became privy to the exact text that Senator Young had spent the prior summer negotiating with Senate President Mike Miller and his Chief of Staff. SB 505 and SB 585 were identical. Senator Young was chided by the chair and others to have this conversation behind closed doors rather than during a public hearing. On March 2nd, Senator Young withdrew his bill and Senator Kelly's bill moved forward. The first appearance of the proposed amendments with the statute of repose language appeared in an email attachment from JPR staff to the then Executive Director and Counsel for the Maryland Catholic Conference, Mary Ellen Russell, and John Steerhoff, a partner at Venable. The email read, "The amendments, as requested, the revised amendments are attached, establishing a statute of repose for certain civil actions relating to child sexual abuse," and noted they were being offered by Senator Zirkin, then chair of the committee in 2017. Approximately 3 hours later, Mary Ellen Russell forwarded the Senate amendments to Delegate Atterbury, a member of the Judiciary Committee and close colleague of Delegate Wilson, the House sponsor, indicating that they may be voted on the following day in JPR. Delegate Atterbury forwarded the amendments to Delegate Wilson. While the vote in JPR didn't take place the next day, a Friday, JPR reported favorably on SB 505 with amendments requested by the Maryland Catholic Conference on the following Monday. And by Wednesday, the 15th, SB 505 passed the Senate unanimously, and the same day, HB 642 breezed through the Judiciary Committee with the same amendments to be passed unanimously by the House. It is clear that in 2017, there was no discussion or debate on the significant constitutional and policy implications of the so-called statute of repose found in the amended version of SB 505 and HB 642. Neither in the committees nor on the floor of the House or Senate, neither the 2017 committee bill files nor the hearing and floor recordings reflect any discussion of the constitutional implications of the so-called statute of repose. Additionally, the revised fiscal and policy note for the bills released 2 days prior to the final passage of HB 642 makes no mention of the significant constitutional and policy implications of the so-called statute of repose. In the summer of 2018, the Pennsylvania report on the 2-year grand jury investigation into widespread sexual abuse of children within 6 dioceses of the Catholic Church in Pennsylvania was released, indicating the abuse of over 1,000 children by more than 300 predator priests. In response to the grand jury report, then Speaker Bush asked Delegate Wilson to reintroduce his bill to eliminate the statute of limitations on child sexual abuse. From records now available, we know that on January 14th of 2019, Venable Law Firm provided a legal brief to the Maryland Catholic Conference on the so-called statute of repose in Section 5-117D of the Courts and Judicial Proceedings article on the issue of whether the General Assembly can enact retroactive legislation to appeal or amend that section. They concluded that such legislation would be held unconstitutional and provided Jennifer Bremen, the then executive director of the Maryland Catholic Conference, 13 pages of case law to support the argument. In response to then Speaker Bush's request, Delegate Wilson introduced HB 687 on February 7th, 2019. There was no look-back window or other retroactive provision included in the bill at this point. During the 2019 session, Delegate Wilson introduced several bills to enact policy recommendations included in the Maryland State Council on Child Abuse and Neglect, SCAN's annual report to the Governor and General Assembly. Sometime in mid-February, Delegate Wilson asked SCAN to assist with HB 687 as well. We recommended that he follow the national movement happening in other states and amend his bill to include a look-back window to allow justice for survivors and protect children from hidden predators. On March 12th, in response to the look-back window provision in the amendment, Judiciary Chairman Clippinger requested a letter of advice from the Office of Counsel to Attorney General. Deputy Counsel for the AG, Catherine Rowe, concluded that the answer to the question of constitutionality was not clear, but that it was possible that retroactive application to barred claims could be held unconstitutional. The courts had not yet decided the issue. Chairman Clippinger put HB 687 with the amendments to a vote on March 14th, and the committee issued a favorable report, 17-4. The following day, on March 15th, then Delegate Dumais, Vice Chairman of the Judiciary Committee in 2017, suggested to Chairman Clippinger that the look-back window was unconstitutional because of a statute of repose. She indicated that she had requested an AG letter of advice, had a legal brief from a large D.C. law firm to support her position, and would propose an amendment on the floor of the House to remove the look-back window. At around 9 o'clock on the evening of March 15th, I received a call from Delegate Wilson. Chairman Clippinger wanted to explain the statute of repose to which Delegate Dumais was referring. Delegate Wilson had no idea what a statute of repose was and why Delegate Dumais was insisting there was a statute of repose that made any retroactive provision unconstitutional. I asked him to get a copy of the legal brief to which Delegate Dumais referred and contacted legal colleagues at Child USA to see if they could help shed light on what a statute of repose was and why reference to it was not showing up in the code. Remember the Venable brief to the Maryland Catholic Conference? This was the brief that Delegate Dumais shared with the AG's office in her request for advice on the constitutionality of the retroactive look-back window. Venable counsel to the Maryland Catholic Conference was the large D.C. law firm to which Delegate Dumais referred in her conversations with Chairman Clippinger. On March 16th, Catherine Rowe issued a second letter of advice on constitutionality of the look-back window. 4 days later, and after being presented the Venable brief, she concluded that the look-back provisions of the statute would likely be found unconstitutional as interfering with vested rights. In a footnote, Ms. Rowe admits that she herself was unaware the 2017 statute made Courts and Judicial Proceedings Section 5117D a statute of repose rather than a statute of limitations when she wrote her letter of advice to Chairman Clippinger 4 days earlier. On March 16th, Delegate Dumais offered her amendment on the floor. Delegate Wilson gave an impassioned argument on the floor to reject the Dumais amendment, as the so-called statute of repose was never his intention, was surreptitiously amended into the 2017 bill, and that he had only learned what a statute of repose was the night before. Members for both parties arose to speak and support Delegate Wilson, saying that they did not intend to vest constitutionally protected rights in sexual predators and those that protect them. The Dumais amendment was rejected 3 to 131, and the House passed HB 687, 135 to 3 on March 18th. On the Senate side, when questioned by the Washington Post and in committee hearing, then Chairman Zirkin said it wasn't anyone's intent to grant permanent immunity in 2017. In the same Post article, Delegate Atterbury said that permanent immunity was never discussed and indicated that she participated in meetings with Archbishop Lori, and that permanent immunity was the sort of conversation she would have remembered. The bill was put to a vote by then Chairman Zirkin on April 3rd. Unfortunately, the current chair had been deployed only days before to Afghanistan, and the bill died in committee with a 5-5 vote. Of the 2017 bill, Delegate Wilson said of the church to the Washington Post, "I was working with them in good faith. They were behind the scenes, crafting language that protects them forever." And during the hearing to his Senate colleagues, it wasn't the intent of the people, and therefore they defrauded the body and the citizens of this state. In both 2020 and 2021, the bill was reintroduced. In 2020, HB 974 passed the House 127 to nothing and included a severability clause in case any provision of the statute was held unconstitutional by the court. And in the 2021 session, cut short by COVID, HB 263 was introduced and withdrawn by the sponsor, and there was no vote in JPR on the cross-file sponsored by Senator Hettleman's SB 134. And those are the facts shared. I'll pass the floor to Ms. Hoke to delve into the legal issues presented. Thank you.
Thank you, Claudia. Mr. Chairman, members of the committee, I'm Kathy Hoke, a professor at the University of Maryland Carey School of Law. And of course, the disclaimer of my presentation is that of myself and not of the school, the university, or the university system. So lawyerly disclaimers aside, I'm here today to talk to you a bit about what is a statute of repose, generally, what it's not, what it looks like in Maryland, as well as then specifically take what we've learned and apply it to Section 117 of the Courts and Judicial Proceedings article. I will try not to sound like a law professor when I do this, but it is what I do. But thank you for your attention on the matter. So what is, oops, wrong way. Used to a clicker, and so this is different. What is a statute of repose? So you have the slides. There's a longer definition and a shorter definition. But essentially, it establishes a time after which a person or an organization is free from liability, regardless of whether a claim has accrued, and regardless of whether there has actually been injury. So the shorter answer is it sets a date certain by which a certain entity can walk away from potential liability, going the wrong way, knowing they can't be subject to civil liability. The purpose of a statute of repose generally is to prevent unpredictability for generally specific and a narrow group of professionals or industries that are engaged in certain trades so that they can predict future claims. It provides economic stability for them and therefore for us, for the marketplace from which we all benefit. Okay, I finally got it going the right way on my first touch. Many of you probably know what a statute of limitations is. So maybe one of the ways to help you understand what a statute of repose is to show the difference. A statute of limitations is procedural, sets a date by which a claim has to be filed after injury has occurred. So the injured party either has been injured and is aware of it or should be aware of it, right? Sometimes that's the standard. And the clock starts to tick from that injury. And they have to file in court. That's a statute of limitations. Catherine explained some of the reasons why we have statutes of limitations. They're procedural. A statute of repose sets a date by which a claim has to be filed regardless of whether or when injury occurs. It is a ticking clock that doesn't depend, isn't triggered by injury. So a little more. What does that then mean? Because we're going to talk about the constitutional implications of that difference. Statutes of limitations can be changed by this body and applied retroactively without constitutional concern. So you can change, you can expand, you can probably not shorten, you can expand statutes of limitation without constitutional concern. Statutes of repose may, we don't have a lot of case law to help us here, may be interpreted as providing a vested property right to not be sued in the person who committed the negligence, right? That altering a statute of repose retroactively may have constitutional concern. So that's really the difference between the two of them. In Maryland, what's the purpose of statutes of repose? Well, we have a case that tells us that here, the General Assembly, has used statutes of repose to create vested property rights, right, to not be sued, in the consideration of the economic best interests of the public. So this is not about whether we're protecting industry, protecting organizations or entities. It is about protecting the public and the public benefit. That is what we know about statutes of repose in Maryland. So, does Maryland have, now it's not going, there we go. No. Okay, my scroll is not, oh, there we go, okay. Statutes of repose in Maryland, do we have any? We have one that I ensure is a statute of repose. Section 5-108 of the Courts and Judicial Proceedings article. This is common among states. So most states have this particular statute of repose. It applies to improvements to real property and the business professionals, the industry professionals that design and then build the improvements to real property. Why? Why is this statute of repose exist in Maryland? It's about us, our economy. Real property improvements, building, as you know, is an economic driver in the state. It's an economic driver in every state. And so to encourage that economic vitality in our state, there is a statute of repose. What does that statute of repose look like? So you see on your screen, or if you can read the tiny print on the slide versions you have, what does this look like? Well, there are two parts of our statute of repose. For the owner of a building, the statute runs for 20 years. For the professionals who designed and built that building, it is 10 years. So that's architects, engineers, and contractors. The owners have 20 years after the date on which the building was made available for its intended use. So if they built a warehouse or a mall or whatever it is, 20 years after it was made available for use, their liability stops, no matter what. For the contractors, for the architects and engineers, it's 10 years. So what does this mean? Kathy, help me apply this, right? So here's an example. A building is designed and built, and the engineer has made a mistake. There's negligence, right? She has done something wrong in the engineering process. No one has been injured yet as a result of that, and 10 years have passed. On year 11, someone is in this building and because of the faulty engineering, they are injured. They absolutely may not sue the architect. Yes, the architect committed negligence. They may not be sued. Despite the fact that the plaintiff wouldn't have known, they didn't get injured until year 11, they can't sue. Guess what? Year 9, day 364, you get injured. Unless you run right to court, your claim is expired as of that 10-year ticking. This is an exceptional measure. This is why Maryland only has one. It's an exceptional measure, and it applies in a very narrow set of circumstances to protect an industry that is meaningful to us from an economic perspective. Here, the language in the statute is clear that it's creating a statute of repose. I'll note to you, it doesn't actually use the word statute of repose because that's not important. That's legal jargon that people have made up to describe what this is. But you, the General Assembly, made clear here what this is supposed to mean. Another point I want to make is that even in this statute, this extraordinary measure, there's an exception. There's an exception for a public health purpose, and that is asbestos exposure. So that statute does not apply to claims related to asbestos exposure. So if you don't know that you were exposed for a period of time, when you knew or should have known, if it was after the 20 years or after the 10 years, then your clock starts to tick in the ordinary course of statutes of limitation. And so even in the context of granting the one statute of repose in Maryland, this body chose to provide a public policy exception that inures to the benefit of the public health. Because this type of remedy, this type of statute is really about the public and inuring to the public benefit. So that exception was necessary. Do we have any other statutes of repose? Obviously, we're going to talk about 5-117, but beyond that, the answer is no. And how do we know? Well, go find them if you can. I couldn't. As the chairman graciously said in the beginning, there's a handful of people in Maryland, lawyers, legislators, law professors, who even know what the statute of repose is. I said to my husband today, I guess I'm an expert on this because the pool of people who even know about it is pretty small. But all humility aside, I've spent a lot of time trying to better understand this. And there's a case I want to bring to your attention that's going to guide the next part of the conversation. And it's important for what it said was not a statute of repose. So in Anderson versus the United States in 2012, you say, well, how is that in state court, Kathy? It is a question that was the federal court hearing a case in Maryland said, we don't know whether your medical malpractice statute in Maryland, Courts and Judicial Proceedings 5-109, so right after 5108, is that a statute of repose or is that just a statute of limitations? We don't know. And they certified that question to what was then our Court of Appeals, now the Supreme Court of Maryland, and said, hey, can you answer this question of whether this statute is one of repose or one of limitations? And the Maryland, then Court of Appeals said, here are the criteria. We're going to walk through them in a minute. And they said no. The medical malpractice statute is not a statute of repose. So that's why I'm telling you there is one. And the court has made clear to us that one that might look like it because some of its language isn't. Let's talk through first a little bit about 5117, what we're talking about, and then the factors that the Anderson court gives us so we can determine whether this is a statute of repose. I suspect you've seen this language, so I'm certainly not going to read it to you. This is what's in the actual codified version of the statute, 5-117D. Again, you don't see the word repose here. This language actually doesn't look like the language in section 5-108 either, which makes clear that regardless of whether a claim has accrued, whether you should have known of an injury, doesn't matter. It's the mere passage of time, once that building is available, that the claims are extinguished. You don't see that language here in 5-117D. What probably is the bigger sticky wicket is the uncodified language that was passed in 2017. Because here we see that magic word, repose, right? Again, that's not used in 5108. But it's used here, and it just is an interpretive provision that was passed uncodified language in 2017 that says that this 5117D is to be applied prospectively and retroactively to provide repose to defendants. That's the language that probably has created the biggest issue here for us in determining whether this is a statute of repose. So let's look at how we figure out whether it actually is one. Questions for us today in 2023, was a statute of repose created in 2017, and if so, what is the impact of a repeal? And I will tell you this. I don't know how many of you in the room are lawyers behind me, in front of me. You hate to answer a client's question this way, but the best answer is I don't know. But the even better answer is, so I said best, the better answer is that it's going to take the Maryland Supreme Court to decide this question. There is genuine legal debate over this question, and it is earnest. I in some intellectual way, love it, right? Having conversations. I'm sorry Senator West walked out because he and I have engaged in great conversation about this. He's a super smart guy, and I enjoy having that conversation. But let's ground it today because we do want to get you comfortable with why you should move this bill along when it comes in, and feel comfort that you've done the right thing and not passed a bill that you know to be unconstitutional. So what the Maryland, I say Supremes because it shortened the heading here and fit on one line, have said on the statute of repose comes from Anderson. They have given us 4 criteria to look at a statute to tell us whether it is a statute of repose. I consider this 2 sets of 2. The first 2 provisions, what triggers the running of the period, and whether the statute eliminates claims that have not yet accrued. So we'll talk about those together. And then what is the purpose of the statute and the legislative history and language, right, around passage. So these are the 4 criteria that Maryland courts have given us to look at. So first, those 2 that I combine, what is the trigger and whether injuries that haven't yet accrued are extinguished. They're related because if the trigger is injury, then it is irrational to ask the second question, right? If the trigger is the injury, then you have to have an injury. And so, injuries that haven't happened yet are not extinguished because you have to have injury. So that relates to that first question is what is the trigger? Is the trigger that starts the clock an injury? And if so, that's not a statute of repose. A statute of repose doesn't look like a statute of limitations at when the injury occurred. Remember, let's look back at that building that got built. It doesn't matter that the person who was injured got injured on year 11 and didn't know they had a claim. Their claim was extinguished when 10 years' time passed. It is not the injury. It doesn't matter if they were injured in year 1 or year 9. It is not the injury that triggers. And the court told us that is the criteria, that is the essential criteria that makes something a statute of repose, right? So, are there claims that haven't yet accrued that are extinguished? Again, doesn't matter. That can't be the case here because there has to be the injury here for there to be the trigger in 5-117. 5-117's tolling provision, the time starts to run when injury occurs. Not some other random date like the delivery of a building, but when the injury occurs. So that says to us, this is exactly what the Court of Appeals said is the difference between a statute of repose and a statute of limitations. So 5117 doesn't meet that criteria, that 2-part criteria. The second part, a little tougher. Let's work through it. The language, history, and purpose support that no statute of repose was created in 2017. Remember, let's go back to that slide about the purpose of statutes of repose in Maryland, consideration of the economic best interests of the public. With that in mind, we look to say, well, so is this a statute that is in the economic best interests of the public? Not of industry, not of business, not of organizations or entities, be they for-profit or not, but for the public. The language used in 5117, as I said before, this is those first two prongs, looks far more like a statute of limitations than a statute of repose. So to be sure, that's what we have here. Now, to the purpose, the intent. I'm gonna skip through these slides because Claudia did a great job explaining what happened in 2017. Just the highlights. There's absolutely nothing in the record that would reflect that anyone described the constitutional implications, if it was a statute of repose, or even what a statute of repose was. There was no amended fiscal and policy note to do so. There was no discussion on the floor, and there was no discussion in committee. We know from members, again, that Claudia quoted, that they had no intention. And we know that for 2 years, your colleagues across the street have sent this bill over, or almost unanimously, and said, we intend to repeal whatever that thing that was created in 2017 is, and we understand that's what the survivors want, and we understand we have the ability to put this legal question out there for debate. We don't have to have an answer to it before we move this bill. And that's really what we're asking today. But let's get to those second two prongs again that Anderson told us. What is the purpose behind this bill to determine whether it's a statute of repose or a statute of limitations? What could possibly be the benefit to the public of providing this extraordinary, possibly constitutionally protected interest to every organization that negligently failed to protect children from the type of sexual abuse that you heard about from Wendy and Catherine? I mean, I'm not kidding. What could it possibly be? Every organizations, maybe not-for-profit or charitable organizations that you believe inure to the public benefit, that do good things, and also the ones that you believe don't do good things for the public. This is every single organization or entity in the state would benefit from this statute. Again, unlike 5-108, which is a very narrow set of defendants who are protected, here it is every organization. Why would this exist if it doesn't exist even for medical malpractice in this state, where we might want to encourage doctors to come and practice in our state, nurses to come and practice in our state? So it just doesn't make sense, the purpose here. So I don't think it's a statute of repose. Again, happy to have the intellectual conversation about why I think that. It doesn't meet the Anderson criteria, but what if it is? What if it is? Again, we're in a place of earnest debate. Claudia told you a little bit about the letters from the Attorney General's office. And I think what we can say is there's not a letter that says, number one, 5-117 is a statute of repose that affords constitutional rights to defendants, or that you can't repeal it retroactively even if it does. There is good lawyer language here that says likely, maybe, because that's the answer. I don't think Kathy Rowe would disagree with me on that point. She says likely one way, I say likely another way, right? And I repeat the question here, what a court would also look at, and that is, we're looking at whether we can take back potentially a right that was afforded or given in 2017 and apply that retroactively. What would be the purpose of doing that? That would inure to the benefit of the survivors, many of whom are in this room right now, and who have spent decades working on this, not for themselves, but for your kids and your grandkids and mine. So this inures to their benefit. It inures to the benefit of our communities. It inures to the benefit of the children of today and tomorrow. So if I'm looking at this from a constitutional inquiry, I'm going to ask that same question and conclude that public policy supports finding this to be constitutional. And finally, what does repealing do here? because there is this extant legal question. And you missed my compliment to you, Senator West, when you were out of the room, that having intellectual debate with you on this question is exhilarating, right? I mean that. I think we respect each other in that way. So or you've at least convinced me of that. But what will happen on a repeal? It's going to go to the Maryland Supreme Court for resolution. I have no doubt about that. There will be an early case filed, there will be early motions filed, and this question will go up to the court to decide. But what you can't control is what happened in 2017. You can't take that language out of the statute and make as if it didn't exist. What you can control is whether you give these survivors the opportunity, the very first ever opportunity for them, something they've been fighting for a really long time and they deserve. You do control whether they'll have that opportunity to make that legal argument in court. That's really what we're asking with the repeal. Not that you have to answer this tough constitutional question, but that you recognize that it is a tough one and you allow the survivors their day in court to argue it. So thanks, and I think we're probably at questions.
Well, thank you very much, all of you, for the presentation. And so, I don't know what the questions are in store for you, but I want to make sure that just for current colleagues and former that, I know in earnest that the debates over this bill and the issues and the constitutional issues associated with it have been in earnest and not for nefarious purposes. So for the folks that were referenced in the presentation that are no longer in the body, I do know that they were arguing under their earnest belief of the veracity of where they were coming from and not for some other nefarious purposes. I want to make sure that that's clear here, and for any line of questioning you get here today, that's exactly where that's coming from, just a legitimate inquiry and an attempt to understand exactly how to move forward. So I just want to preface the line of our questioning, and then also our former colleagues that were referenced in the statement or in the presentation, that's where everyone was coming from. So with that, I'll open up for a committee of questions. I have a few myself, but I'll open up to the committee for questions. Senator Folden.
Thank you, Mr. Chairman. I have a couple questions. I'm sorry, I got to get your, Ms. Robb, if I could ask, I just have one question for you. On one of your slides, slide 16, you reported that less than 20% of sex crimes are referred for prosecution. So I'm curious, was this something that were actually reported to the police? Those were less than 20 were referred for prosecution?
Exactly.
So this wasn't like a study or estimation. This was of reported sex offenses, less than 20% were referred for prosecution.
That's correct.
Okay, I just wanted to get clarity.
And I can share that study.
I would love to, because that's
Okay.
just,
Great.
that
There are some
should be
others.
bothersome to many people.
Yeah, there's some others from the CDC and the FBI as well.
Okay, great.
Yep.
Yes, I appreciate it. And I do want to say, your passion and the way you have the resolve that you come forward in this and the way you present this, it's very inspirational. So I want to applaud you for coming in and the way you advocate for those that can't. So
Thank you.
I appreciate that.
I do this for children.
Yeah, it's amazing. So thank you.
Thank you.
And then I have one more, please. I'm sorry to have speakers jump around. Dr. Hope, may I ask you?
My brother's a doctor, my sister-in-law's a doctor, but I'm just Kathy.
Okay, all right.
Hope would be fine.
So I just,
And welcome back, Senator.
thank you. So really fascinating points. I mean, if you remember me from before, since you welcomed me back, apparently you do.
Well, apparently you don't remember me. I'm kind of proud of that.
I do. I just didn't know that you did. I was like, wow, this is great. I'm not sure everybody feels
I
that
should
way,
say
by
to
the
your
way.
colleague, welcome back.
That's right. So under the statute of repose, or I'll just say, when you were giving the explanation of the 5-108, the statute of repose, I was curious because when you were explaining it, it was really specific that you used the word, and I'm going to ask, assuming that it was from the definition itself, but it states about negligence through the acts of negligence is basic, summarizing it. Is that correct within the framework of how it's in the statute of repose that it references negligence?
Well, for 5-108, the protection is for builders, and it is about negligent conduct. Thanks for asking the question, because it's helpful for me to get to answer it, that the conduct that we're talking about here primarily is also negligence, not intentional conduct, because we're talking about the liability of the organizations, entities, and businesses who failed to supervise.
Okay.
And that is a negligence claim.
Okay, because that's where I was trying
Right.
to clarify, because the acts are actually malicious and intentional. So is there, and I guess I can ask you this on a sidebar, but, to me, it seems like that there should be maybe a carve-out, because I was I looked back, because this was all very familiar, I was one of the original co-sponsors from the House side in 17, and there was only I think 6 of us. But when I was hearing you speak again, it was all coming back to me, and I remember about the negligence part versus the whole wonderful presentation you gave, So I just want to make sure we're clear on that. I was wondering if there might be a carve-out well, I'll speak with you on the side about that, because I want to ask.
I will come by your office.
Okay, great.
Well, it sounds like you have a colleague who wants to
Well, I was looking at the carve-out, because they did a carve-out for asbestos, but, when we're talking about the statute of repose, a lot of times it's being applied because it's actually, like you were saying, it's an economic driver, it's one that you're trying to limit the liability. So if we're looking at it through that lens, this is an intentional malicious act. Is there a way for us to then somehow codify the language that would eliminate any negligence discussion and make it that if there's a willful and wanton disregard for the safety of a child or minor through these acts, because it is willful, it is wanton, and it is negligent, or not negligent, malicious. And that would be something that I was wanting to discuss, to see if
Yeah.
in your thoughts, if that was some language that could be added in to help us kind of bring this back full circle and not have to deal with where we bumped it from, because the original bill was a 7-year original statute of repose, or it was a limitation.
Limitation.
It wasn't a statute of repose. It was written as a 7-year limitation on being able to, once you became an adult, to be able to file a claim civilly. And then this bill took that, and we were able to argue this and bump it to, basically, you could be, I think it was 20 years.
Well, 38.
38.
Yeah.
Right? Because I remember thinking 38 was kind of an arbitrary thing, and they're like, well, we're just doing it as a 20 on top of adulthood. So, which leads me to my next question, is it only, we moved it from 7 to 20, what's to say in this carve-out, if making negligence a part of this doesn't work, what's to say we couldn't say that the bump would be, okay, we're going to have, for this specific malicious act, it would be a 50-year statute of repose,
So let me just.
or that
Yeah,
term.
there is a distinction here. There can be claims of child sexual assault, civil claims, brought under Section 5-117 against the actual perpetrator, the teacher, the coach, the
This is the
minister who
institution.
actually engaged in the sexual assault. That is one potential defendant in these cases. Those defendants also can be charged criminally, as Catherine noted, and there's no statute of limitations
Okay.
for charging them.
Okay.
But this statute is really actually about, and the focus here is about, those who failed to effectively supervise,
Okay.
and that is a negligence claim.
Okay.
And so we don't want to carve out just for intentional behavior, because it won't get
I
at
got you.
essentially the bad actors who let it happen for decades.
Yeah, I understand. Okay, that makes sense.
Thanks.
That's all. Thank you.
Sure.
So just while you're there, just before we get into another line of questioning, for the carve-out for asbestos, did that apply prospectively or retro?
I gotta look, and I don't know, and I'm sorry, I don't know.
Yeah, that would be an important, although I know we're kind of in either limitations or repose
Right.
lanes here, but if you're in the repose lane, it
Yeah.
would be important to understand if that applied retroactively or was it just prospectively?
Yeah.
Otherwise, we think we should add lead to it as well. But anyway, so.
Not opposed.
Got it. I see we have a couple, do you have a question too? All right. Before we do jump there, just a guide, because I want to tag on to where Senator Fulton was going. Just so for the first piece, I support, yes, Professor, you say it there. support the legislation, and the question that I'm going to ask, obviously, we need to refine some of this stuff so that when we move forward, if the legislation goes forward, then I'll be able to answer those questions as well. So one piece is legislative intent, whether statute of limitations or repose. And when you noted this as well, like in the uncodified language, the repose language is there.
Right.
It says the statute of repose under section 5117 of the court article is enacted by the section of 1 of this act shall be construed to apply both prospectively and retroactively to provide repose to defendants regarding actions that were barred, so on and so forth. In the bill, there's also purpose language that speaks to establishing a statute of repose. And these are questions that we are going to get not only in committee and on the floor, and which will turn. So one is of legislative intent, understanding that you have a few prominent legislators that are deeply steeped in this issue that sponsored it and that got into it on the committee that said they did not know or that was not their intent. That's well-established legislative history. But the words are the words. And so that's something we need to kind of discuss.
Absolutely. Yeah. So first of all, again, that language was put in to the bill. You can call something a duck, but if it's not a duck, it's not a duck, right? And so that's why probably more important than that one word, repose, those, pesky, 6 letters that have been, a sticking point here, we can say, what does that actually mean? And so I'm not going to say we ignore them. We don't. But can we find some basis in the law that says it doesn't have to be that legal terminology, what that means, just because that word was used? So I'll remind first that Section 5-108, which is the statute of repose in Maryland, does not use that language, right? Does not use that language. And the Anderson Court didn't find using that language to be important, but rather language that makes clear that this acts like a duck, right? That this acts like a statute of repose. That something other than the injury is the trigger that starts the clock ticking, and that claims that haven't even accrued are extinguished over the passage of time. So we can look at that and say, well, that's a word that's used, but if it doesn't accurately describe what's happening in the bill, we can discard that word. There's also Maryland Court of Appeals, and I'm tripping over that Court of Appeals Supreme Court thing, but it was then the Maryland Court of Appeals, the Gomez case in 2012, that, talks about it's, appropriate to look at legislative intent even when the language of the statute seems clear. So why, if that language is in there, can we care about the legislative intent, even go back and look at it? And Kozarowski, which is actually probably one of the most cited Maryland cases in my area of practice for a variety of reasons, that courts are not limited to the words in a statute to figure out its meaning, right? And so this is a question. Why are those words in there? Those words are in there because there were people who wanted this to be and to function like a statute of repose. But the mistake is it doesn't act like one. So they've called it a duck. It doesn't quack. It doesn't waddle. It is not a statute of repose despite those words.
No, I appreciate that explanation, and I appreciate you passing along the Anderson case. You pulled it up, and the 5-factor test, so I appreciate that. And obviously the language is distinguishable in 5-108 and 5-111, 117. So then the second thing, so if we're not in repose land, let's say, we are in limitations land, is what is in the statute now, age of majority plus 20, is that a statute of limitations?
Yes.
Okay.
Yeah, just like the medical malpractice
Got
one,
it.
which also looks a bit like a repose because it says after 5 years you can't bring a claim, but the Anderson court said it's not a statute of repose, it's of limitation.
So okay, so then this is the questions I'm going to get. So then you're familiar with the Smith-Westinghouse case and the Dua Comcast case.
Yep.
So then they take painstaking language to talk about the confines and the vested rights that accrue with the statute of limitations.
Right.
And so understanding, and I thank you for the good rundown with the difference between a repose and limitation, because obviously the repose is a stronger kind of date certain
Right.
than a statute of limitations. But if and I'll read some of these excerpts, but I mean, I do want you, can you just give us a rundown of Smith versus the Westinghouse case, and then also the Dua, and if not, I can refresh your memory, but.
Yeah, refresh me, but I think I have the answer, but yeah, refresh
So
me.
just because the language is pretty strong.
Yes.
And these are all Court of Appeals cases, Supreme Court cases now, whatever,
Yeah.
Court of Appeals cases. So it seems, at first blush reading, it seems pretty definitive. So these are issues that we have to deal with.
Right.
And so this is from, the court has consistently held that the Maryland Constitution ordinarily precludes the legislature, one, from retroactively abolishing an accrued cause of action, thereby depriving the plaintiff of a vested right, and then two, from retroactively creating a cause of action or reviving a barred cause of action, thereby violating a vested right of the defendant. That's the Comcast case, the do over Comcast. And the Smith Westinghouse case, so the Comcast case, I think, is from 2000, is it 2000? Anyway, 2000. 2002, maybe. So then, in Smith, it's just a statutory provision retroactively extending the statute of limitations for wrongful death actions, resulting in reviving causes of action that have been barred by the running of limitations going forward, contain provision making the statute retroactive, barred. So, and I can go on with the Dua case, and I can read and read and read and read. The point is this, like, that's. So if we distinguish between limitations and repose, now we're in limitations land.
Yep.
The question that's going to be posed is it not clear where the Court of Appeal or the Supreme Court
Right.
stands on this?
Yeah.
In terms of a vested right.
Yeah, I thought you wanted the facts of those cases, which is why.
No.
I was like, why are you doing that to me? No, I'm joking. I'm not in class. I wouldn't do that to you. When I am, I'm usually on the other side of that. But no, so you're right. There is Maryland Court of Appeals case law that even makes us hesitate to say that a statute of limitations can be changed and apply retroactively. And earlier, I think I even corrected myself to say, at least if it's being expanded. It's pretty clear that a statute of limitations can't cut off a plaintiff who had a cause of action but just hadn't run to the court and filed yet, right? So if you were injured and you had a 3-year statute of limitations and it's only year 1, the General Assembly can't come along and say, oops, now you waited, we've made it into a 1 year and your time has expired. We know that that can't happen to cut off the right to sue that was vested. The tougher question, and the question that we really have before us today, is whether that can be expanded retroactively, which is what we're purporting to do here. And certainly these cases are not helpful. If I was writing a law school exam, they're the ones I would focus on as well. But I don't think that they were either of them really focused. The holdings in those cases are not really focused on the particular question posed here. They bite around the edges of it, and they certainly aren't helpful. But even Kathy Rowe, who cites both of those cases in her letter, still says likely. She doesn't use those cases as the hammer that says there's not a window of opportunity here to argue that these are not constitutionally protected rights that can never be interfered with. And that's where we get to the last point that I was making earlier, and that is, if ever there was a time for the courts to say, is there a time when we would allow for the expansion of even a statute of limitations that would give people the ability to sue past when they previously had, given Dua, given Smith? This is it, right? When these are people who never had a legitimate opportunity to come to court, that when they were the 8-year-old and 9-year-old being injured, the statute of limitations was only 3 years. They would have had to be 21. Catherine told us it's not until your 40s or 50s that you even come to accept, acknowledge, and understand that harm. So I think that tiny window of opportunity that exists for us, despite Dua and Smith, even as Kathy Rowe recognizes in her letter, gives us that window, and we'd like to push it open.
Excellent. Thank you for that. I mean, it's never been a doubt of whether it's good public policy. It's
Yep.
whether it's the constitutionality. Senator West. Senator McKay first, then Senator West.
Thank you, Mr. Chairman. Thank you to the panelists. Appreciate all your information today. My question is for Ms. Robb. Hello.
Hello.
So as a layperson, as a member of this committee, I'm interested in, don't have to have the answer now, but get some information later, some supporting data on why age around 52 is the time of understanding the harm and such. As I build a foundation here, I need to build that upon solid
Sure.
rock, so.
Happy to share that as well. And there's a lot of data on it, especially the age 50 to 70 as well.
Wonderful. Thank you
Okay,
very much.
great.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Professor Hook, why don't I start by asking you a couple of questions? Yeah.
Did I say that?
And before I do, let me suggest to the audience that this is how we work in Annapolis. We work as colleagues. We treat each other with respect. Contrast that with Washington, which you see on the news every night, where this doesn't happen, but this is how we work in Annapolis. So Professor Hook and I think, are probably on different sides of this issue, but we have a very respectful relationship. So the first thing I wanted to do was read into the record the actual sentence from the Maryland Code that we're talking about, because we've talked a lot about it, but the actual language of the sentence, the actual words have not been read. So let me read it, and I want to ask you a question about it. Here's what it says. It says, "In no event may an action for damages arising out of an alleged incident or incidents of sexual abuse that occurred while the victim was a minor be filed against a person or a governmental entity that is not the alleged perpetrator more than 20 years after the date on which the victim reaches the age of majority." That's the sentence. So my first question is, do you believe that there's anything ambiguous about the language in that sentence?
Sure, and again, you were out of the room. I did have that, in full disclosure, I did have that.
Oh, I'm sorry, I was out of the
No,
room
it's
for
totally
about
fair.
20 minutes.
I just want to let you know, I didn't try to hide that, right? That language.
Two bill hearings in another committee.
Again, I more than understand that.
Right.
I thought you were getting lunch. So I would say, if I didn't know anything about the statute of repeals and spent the last 2+ years working on it, that maybe it's not ambiguous, right?
Maybe?
Maybe it wouldn't be ambiguous because it says in no event, but I wouldn't know what that means legally, right? It says in no event. Right? But we just talked about whether statutes of repose or statutes of limitation can be retroactively eliminated or expanded. What I've come to understand, it's less about this actual language here in no event. Maryland courts have told us, even sometimes when the language appears to be clear, we can look at intent and actual word, we can take and look at the words. What I know about statutes of repose, this statute 5117 doesn't function like a statute of repose.
Let me ask you this, along the same lines. So you would agree that the general rule in Maryland is that the plain language of the statute governs?
Yep.
It's been said over and over and over again by the Maryland by the Maryland Supreme Court. All habits are going to die hard. You'll have to deal with me for a while on this.
They could have waited until we were done practicing to make that change.
So the plain language of the statute governs, and if that's the case, if the statute language is plain and unambiguous on its face, there's no need to resort to extrinsic information to try to interpret language which is plain on its face. So in this case, I thought that the discussion of all the legislative history of that language was fascinating, but I think it's irrelevant. But you would contend that even though this language maybe is unambiguous, that nonetheless, even if the language is unambiguous, we still should resort to legislative history in order to interpret unambiguous language.
Yes, so for a couple of reasons. First is, it is in fact a principle of statutory interpretation that we teach our students at the University of Maryland Law School. One of the primary prongs is, what does the legislative unambiguous, clear legislative language tell us? But it is a falsity to suggest, even in Maryland or in any other state, that that is the only principle, that once you get there, you don't go past it if your answer is this language appears to be clear. Right? There is the Gomez case and the Kazarovsky case that together tell us that sometimes language appears to be clear, But if we take a look back at legislative history and the purpose of the provision, we realize that it's not. And I'd say that's what is the situation here. So there are competing principles of statutory interpretation. One is not the king who can't be knocked off. If the answer is this, the flow chart tells us we can't look at legislative history. Even the Maryland Court of Appeals, Supreme Court has said there are times when when we think the language is clear, we're going to look to see, does this make sense? Does this fit with the purpose, what seemed to be the purpose? So legislative history can become relevant even with clear language.
And in order to establish to the satisfaction of the Maryland Supreme Court that a statute at this point could be passed, which would change what appears on its face to be a statute of repose, your method of doing that would be to introduce, to call as witnesses members of the General Assembly, who, even those who worked on the bill, who would testify that when they voted for a bill that they worked on, they didn't understand what they were doing, and they didn't understand the import of the language. That's what you're saying?
Well, I mean, I want to recognize the discomfort that Chairman Smith just acknowledged, that we're talking about some of your colleagues who then have made public statements, and, I want to treat them, at their word when they've, spoken about this. The Weasley answer is, I'm not a litigator, right? I'm a law professor here, so I won't.
That is the Weasley answer.
Yeah, right, that is Weasley. So I'll give you, I'll try to put myself in the shoes of a lawyer who was trying this case. I don't know that I would feel the need to go that far. Because I think we can look at the legislative record. I think we can look at, hearings, fiscal note, floor debates or discussions, and then really, again, principally applying the four-prong test from Anderson to the language of the bill to determine if it was a statute of repose. So to me, the legislative intent is probably, having to prove that part of it is tangential to saying the actual language in this statute doesn't really look, because it doesn't function like a statute of repose, and that is based on that trigger, what triggers the running of the period.
But if this is the way to establish that a statute which is unambiguous on its face, in fact, means something that it doesn't say it means, doesn't this open the door in the future to getting legislators to come before the courts and testify, I didn't know what I was doing when I voted for this bill, and therefore you should interpret the bill in a way that the bill doesn't read?
Yeah, again, why I put that as a tangential issue is, calling any member as to what their intent was. I prefer to stick with what we have in official record, right? No discussion of this in committee, no discussion of this in fiscal and policy note, no discussion of this on the floor, nothing in the formal bill files on it, and then the functionality. And so I avoid the problem I think is an absolutely legitimate concern, and we would never want to be in the situation of, you all don't want to be dragged into court to say what you intended, and what one member versus the other, 187 of you intended, is just a tiny piece of information. So again, I won't try this case because I'm not that lawyer, but I would not do that.
Well, let me try it another way. So the simple fact, which everybody around the table knows, is that many of the bills that we passed on the floor are not really the subject of any discussion. There's a floor leader who briefly summarizes the bill in 2 or 3 sentences, and then there's a motion, and everybody votes in favor of it. So if what you're saying is how bills can be changed or laws can be changed in the future, it would enable, in those cases where there's no discussion on the floor, someone to come in and testify before a court, I didn't know what I was doing, I didn't really intend to vote for the actual language of that bill, and this court ought to change what the General Assembly passed and in fact rewrite the language of legislation. Isn't that correct?
So no, I don't think you'd have to rewrite the language of the legislation, because I'm saying that the language in the legislation doesn't function like a statute of repose. So I don't have to change anything that was passed in 2017 to say this is not a statute of repose. I'm not dependent upon testimony from legislators to get there, because I look at just the use of the word repose or at no event doesn't mean this vested constitutionally protected rights in defendants. And so I don't have to go that far. And I wouldn't want to, because it would not be consistent with, how statutory interpretation should occur.
So let me change slant just a little bit. Going back into the middle of the sentence that I read, it says, Let me read it in quickly, and then, in no event may an action for damages arising out of an alleged incident or incidents of sexual abuse that occurred while the victim was a minor be filed against a person or a government entity that is not the alleged perpetrator, et cetera, et cetera.
Yep.
So, do you understand this language to mean that under current law, someone who is beyond the age of 38 has the right to file suit against the alleged perpetrator?
Yes, because there is not, the 20 years doesn't apply to them. And that's the point I was making to your colleague, Senator Folden, that there's a difference between the intentional actor and the negligent actor.
Okay, so what this hearing is all about and what House Bill 1 will be about when we get it is not about the ability of someone to sue the alleged perpetrator, but the ability of someone to sue some other organization that allegedly acted negligently because they didn't stop the alleged perpetrator. Okay, so now let me give you a hypothetical, if I could. I'm 72 years old. That's a matter of fact.
You look great.
That's not hypothetical, that's fact. I'm 72.
Oh, okay, you really are 72. Okay.
So, fortunately, I was not abused, but let's assume I was abused at 10. So that happened 62 years ago. I'm well beyond 38 years old. So if House Bill 1 were to be passed, I would have a right to file a suit. Well, right now, I have a right to file a suit against the perpetrator of the abuse, who's probably not alive any longer because it happened so long ago. So if this bill passes, I would have a right to file a lawsuit against other people in the organization who at the time failed to stop the perpetrator, but they're probably all dead too. Anybody else who might have any direct knowledge of it is probably dead. It was 62 years ago that it would have happened. And probably any documents relating to it that might have existed at the time have long since been discarded. So, and there's no limit, correct, to how much I could sue the organization. I could sue them for $100 million, right?
Yes, under the current version of HB1, there are not caps on liability.
Right, and one of your members, I think it was Ms. Robb, stated that it would be wrong to establish a cap. So there's no cap. If House Bill 1 passed with no cap, I could file suit for something that happened 62 years ago for $100 million, and it's entirely likely, is it not, that the defendant, whatever organization it was, would have no defense in court, because there are no witnesses available, there are no documents available. So isn't it likely that the only person who testified in court would be the very elderly, and 72 is pretty elderly, the very elderly plaintiff who would then pour out his story or her story to the jury and ask for $100 million?
So no, because there are some fundamental assumptions that are wrong in the hypothetical.
Okay.
And so first, the organization is the defendant. So let's just make that clear. There aren't individuals who were sued. It'll be the organization.
Well, if people are still alive,
Correct.
For the organization at the time.
Correct.
They could be defendants as
Correct.
well. You had the chance to stop this, but you didn't.
Right. So let's remember a couple of things that stand for all cases. The burden of proof here is on the plaintiff. And they can't just walk into court and think they get to say something and get believed and win. They have a tremendous burden of proof. But
It's
also,
preponderance of the evidence.
preponderance of the evidence,
more
which
than half.
is not the same as the criminal standard, but it's still a standard. It
Yeah.
still is a burden on the plaintiff.
But isn't it correct that if the defendant has no defense, that has no one to can testify and no documents?
No, I dare say you could go to circuit court today and have plaintiffs going into court claiming something happened to them and they're not believed.
Okay.
It's not thought that they have sufficient evidence to prove their claim and they lose, right? So, but here's the real issue. There's an assumption that there isn't any other evidence. And in many of the cases for the survivors who are your age or older or younger, there actually is evidence. We know that with respect to some of the potential defendants in this case because the Attorney General has prepared, and it's yet to be publicly released, the report on the Catholic Church in Baltimore, right? And that is based on, I can tell you, I promise you, it is based on decades of evidence documentary evidence, witness interviewing evidence, both of victims, victims' families, other survivors, of people who worked for the church and were witnesses. And so it's false to suggest that just because the time has passed, that there's only the living survivor who can come in and give testimony, and that's what the court is going to have to decide on.
Okay.
Remember, it is still the burden on the plaintiff, and many people will not have, because of the passage of time, witnesses or documentary support to bring their claims. And they'll struggle to find a lawyer to bring that claim. They'll struggle to demonstrate that claim in court. But that's for the court system to decide. We have rules of procedure and standards for evidence that will decide whether that claim can go forward and whether that plaintiff can prevail.
Great. Thank you so much. I always enjoy talking with you. Ms. Robb, could I talk to you just for a moment, briefly? I didn't understand one part of your presentation because I couldn't read it on the screen. It was too grayed out, and it's very small in my...
And he's 72.
And I'm 72. Thank you, yes. So you talked about bankruptcy, and there was the slide 33 on bankruptcy. I wasn't sure exactly what you were saying. Were you saying that an organization that gets, say, a $100 million judgment against it is not permitted to file bankruptcy or should not be permitted to file bankruptcy?
No, I think it's a fair question, thank you. I think my point was, and perhaps I didn't make it well, but my point was that I think the way the average person thinks about bankruptcy, if you ask someone who didn't go to law school, who doesn't understand it, what does the term bankrupt mean? That's not what happens in the real world, right? Bankruptcy, at least Chapter 11 bankruptcy, right, which is what we're talking about here, is a reorganization, right? It's very different. It's a very different concept legally than what the average person would think. It's a scare tactic. Oh my God, we're going to go bankrupt. We won't be able to provide services. That is not true, is my point. My point is that in Chapter 11 bankruptcy, the institution gets to reorganize. They get to be relieved of a lot of their debts. They get a new day, right?
Well,
they can still be active, provide the services, that sort of thing. So just sort of illustrating that point. Now, there are also a lot of procedural problems with Chapter 11 bankruptcy. Presently, Congress is working on those. We're working with some members in Congress about really making changes specifically, very specifically for child sexual abuse claims.
But it is correct, is it not, that even in Chapter 11 bankruptcy, the person filing the Chapter 11 has to marshal assets and sell assets in order to pay claims.
That is correct.
So if there's an organization, for example, that has an entire school system, they might have to sell off all that land, close the schools, and sell off the land in order to raise money to pay claims.
I would disagree with that.
Why?
Because we have the third-party folks who are, they're insurance carriers that will come in.
To the tune of $100 million?
No, well, I don't know. I mean, I don't know. It depends on people's coverage, and this would be, very fact-dependent.
Okay, but it is possible, is it not, that if the insurance doesn't cover all of the claims established in court against the organization, they would have to sell off its assets in order to raise the money to pay the claims in the Chapter 11 bankruptcy?
Possible, but unlikely.
Okay, thank you.
Thank you.
What is the longest tail on insurance you could possibly get? Like, how long could you go back for that? I don't know. Okay.
You'd have to buy it.
Well, I know, but how long could you extend it for? How long could a tail be for an insurance policy?
So I'm not an insurance expert, but it's a matter of contract law between the purchaser of the insurance and the issuer. So if the purchaser of the insurance wants a tail which would protect him from multiple $100 million judgments, the tail is going to be very expensive.
No, I get that, yeah. Understood. Let's hear Senator James and then Senator Folden.
Thank you. I have a lot of questions, but I don't want to make this hearing any longer. What would really be helpful to me for now would be to get the slide presentation in a normal size so I can read it. I couldn't see it here very well. I could tell you which ones I wanted, but that seems to be so laborious. but particularly the briefing that I think Ms. Remington did that has I think it's sort of your interpretation of the legislative history of the prior years, and then Professor Hope's. But in reality, all of them, if they could be normal-sized, would be helpful to me.
Yeah, so committee staff does have them in that version. That's how we
You also have them-
I think they printed them out for you in that.
Yeah, they're also in your system, your floor system.
Well, they're not in the floor system, but they are, if you go to the Maryland General Assembly hearing schedule, they're under briefing materials in the hearing schedule, so you can print them all off. They were a lot of pages, so we were trying to keep them manageable.
And
But you can
then-
access to your floor system.
And then just to follow up, full disclosure, I've partnered Venable, not at the moment, but for a long time. So you all are referring a lot to their research and memorandum and letters. Do you have that? Does anybody have that?
We have a copy of it. Happy to.
Could you share that with me?
Yes.
And I don't know who else would like it. Thank you. Thank you, Mr. Jones.
I'm good.
Well, this has been exhilarating. Seeing no, actually, Senator Sidnor, yes.
Trying to think. Ms. Robb, actually, I had a question for. You were kind of, when you were raising the issues that you were raising, you were kind of talking at a federal level, so I'm assuming you've had plenty of conversations about this stuff nationally. And I'm curious, and this question is not specifically for what you're talking about, but I'm just curious about other discussions, because as I'm sitting here and I'm listening to this, the conversation about people who have been harmed in the past and then not being able to feel made whole because of our civil law, I cannot help but think about the conversations about reparations. And I'm really trying to understand how this conversation and what you're asking for could be used in that context. Because there are a lot of people who have been hurt in the past and could probably make similar claims regarding institutions and rape. And so I'm just curious if you've heard any discussions around that as you've been presenting or making your presentations.
You know, it did come up in a private conversation. I do think that there are differences that we did discuss. I personally, professionally believe that when people are harmed, whether it's small groups of people or very large groups of people, by their identity, that there should be recovery and people should be made whole as best as the law can provide that. But we don't have a history, a museum of history for sexual abuse survivors. It also cuts across every denomination, every race, every religion, every party.
And just to be clear, what I'm asking, I'm strictly talking about the legal arguments.
Right.
I'm not asking for your policy and what you believe and what you don't believe. I'm asking about legal arguments. Because again, in my mind, I'm wondering, all right, if we're making this legal argument, how can I use, because there are a lot of people, constituents of mine. I was just contacted the other day with a constituent who's interested in the legislation that's been introduced in this General Assembly for the past 3 years that continued to fail. And to be honest, I don't know if this body intends on taking that type of legislation up, but I'm curious about the legal arguments that you're making.
Well, I think that a lot of them would apply.
Okay.
I think they would apply. I think, you know, as Professor Hoke spoke about, there are the rules of evidence, there are the rules of civil procedure, and, you know, these parties have an uphill battle. You know, I often say, you know, child abuse survivors child sexual abuse survivors have to survive a 12B motion to dismiss. These are not easy to do, and many attorneys won't even take the case if they're weak, if there's weak evidence.
And I mean, and again, I've heard the same arguments just about societal trauma. And I'm not even just talking about slavery. I mean, the reality is my father was born in 1953. He was born during an age of discrimination and segregation. He's lived through this stuff. So it's not like we're talking ancient history here, but there were people who, through legal machinations, were prevented from getting proper remedies.
Agreed.
So as I'm listening, that's where my mind, I mean, I hear you all, and I'm sorry for what you all went through, but I'm always curious, well, how do you take these arguments that are being made and put it in this context? How does it apply in this context? So I do thank you for that.
Yeah, and I would just say, personally, for myself, I believe there's an enormous amount of racial trauma in this country. It is another discussion, and I see it. I see it daily, as we all do. Hopefully, we are awake to it. But thank you.
Thank you very much, Senator Sidnor. That did come up, actually. It's funny that you brought that up, because I brought that up, too. Interesting fact is, the UK, we talked about this, in 1837, there's a Slave Compensation Act passed in the United Kingdom because they ended slavery and paid the slave owners for reparations for freeing their slaves, and that bill just got satisfied in 2015. 2015 to the descendants of slave owners, so it was reparations in the opposite. Interesting. 2015. Anyway, all right. Thank you all very much for this. This has been tremendously enlightening, and also just thank you for your work and your tenacity on this issue. Looking forward to working with you. So thank you very much. Thanks. All right. All right.
Good afternoon, Chairman Smith, members of the committee. Thank you for the invitation to speak with you today at this briefing about the proposals you're considering regarding the statute of limitations for childhood sexual abuse in Maryland. My name is Carrie Silverman. I'm an attorney at a law firm in D.C., Shikardi and Bacon, which is primarily known for product liability work. We don't work in childhood sexual abuse in cases for plaintiffs or defendants. I'm also an adjunct professor at George Washington University Law School. I'm not here in that capacity. I'm a Maryland resident and a member of the Maryland Bar. And I'm here today on behalf of the American Tort Reform Association, and that's a national coalition of businesses, nonprofit organizations, municipalities, and others that promote fairness and balance and predictability in civil litigation. I've unfortunately testified across the country on similar bills that you're considering today, including before this committee in the past. And I've also filed amicus briefs on behalf of ATRA, the American Tort Reform Association, and other groups in a number of states that are considering challenges to these types of laws. I appreciate and respect the advocates that have presented before you today. Very thorough presentations. There will be some places where we disagree, and there are other places where I think we may be in agreement. But I think what I'll present to you today offers another perspective, another point of view on the types of proposals that you're considering. I'm not here as any sort of expert on the science underlying abuse. I'm going to be backing up today and talking about the general principles underlying statutes of limitations and why organizations like ATRA and the members of an organization like that are concerned when they see a bill that would potentially eliminate a civil statute of limitations entirely, which is unprecedented, and to retroactively revive time-barred claims. So what I'm going to talk about today is number one, and give me some patience. I understand most of you are lawyers, but I do think that it's helpful to back up and think about why we have statutes of limitations and why they're set at certain levels. Because we probably spent about 3 minutes on that in law school. You know it's there as a lawyer. You know you got to follow in a certain time period, but you don't give much thought as to why is this period 3 and this 10 and this 20. So I'll take you through that a little bit. Then I'll talk about why ATRA is concerned with a proposal like this that is limited to childhood sexual abuse. But, you know, as I'll show in my presentation, there's a lot of ways that this would go in other directions if this precedent is set here today. And then next I want to talk a little bit, and Ms. Robb talked about this too, but how other states have acted in this area. You know, who's done what? A lot of states have revived time-barred claims, that's true, but there have been some significant sort of fine print on that hasn't been discussed today that I think ought to be considered. And then I will talk about with you a little bit about the constitutionality of reviving time-barred claims, what the state of the law is on that nationally, and what the state of law, a little bit more about Maryland in that respect. And you've had a lot of discussion already on that point, but maybe I can offer a few more observations. So I think statutes of limitations are sometimes misperceived as being there as just arbitrary numbers, as being a trap, you know, for an injured party to lose their claim. I mean, when you're watching your television at night and you hear those lawyer ads come on, they say, call us right now, you may have a claim. They're talking about the statute of limitations and the need to file a claim within a certain amount of time. So the public's familiar in that sense with statute of limitations, and whether you're a lawyer or not, you kind of have some understanding of that they're out there. But why are they there, and how do we set them? We have statutes of limitations. It's not about taking away a person's right to sue. It's not supposed to be a trap. It's there to protect the justice system. It's there so that we have a civil justice system where our judges and our juries can decide civil liability, you know, based on when the best evidence is available to do it. When we have the records available, when we have the parties and witnesses available, when the memories are fresh, and when how, you know, a party acted or how they should have acted, you know, in these types of negligence claims that we're talking about, can be evaluated based on what the best practices are of the current time period, okay? When a claim is filed long after an injury has occurred, likely the employees from that time have moved on, you know, the witnesses have passed away, the institutional knowledge of what the policies were isn't there anymore, the employment records may have been legitimately discarded, and that's why we have those statutes of limitations. And advocates, you heard earlier, advocates will point out, of course, a plaintiff always has the burden of proof, right? I mean, they always have the burden of proof. But it's not in the civil system a tremendous burden to meet that standard. And the burden of proof is a preponderance of the evidence. There's no, you know, sort of safeguards, you know, as you see in the criminal justice system where you've got a prosecutor where you've got to get an arrest and probable cause, and you've got a grand jury and an indictment, and before you get to the stage of filing a case in a civil case. You just walk in and anyone could file a civil claim, right? And then it goes forward, and the question becomes preponderance of the evidence. Is it more likely than not, which is basically a 51% chance that someone is at least partially responsible for what occurred. And that's not a high burden, especially when the plaintiff is a person who has undoubtedly experienced a tragic, horrible injury in their past due to what was absolutely reprehensible conduct. That may be disputed in some cases, but in a lot of cases it probably won't be. So the issue in those cases isn't whether the abuse occurred. It isn't whether the person's injured horribly. The issue is whether the organization, at whatever time it was looking back, what they knew or what, and this is key, what they should have known, what they should have done at that time to maybe detect a person who was a risk through their hiring practice, to have more closely supervised that person, to have trainings in place, what have you. What should they have done back at that time to fulfill their standard of care? And when you don't have the records and the witnesses available, that's going to be a hard defense to make. Why are statutes of limitations set one level or another? Does the length reflect the severity of the injury? The answer is no. It doesn't reflect the severity of the injury. You could have a paraplegic who is, hurt by a drunk driver. Time to bring that claim is 3 years. You could have a person who is maimed by a defective product, 3 years. Death due to a reckless conduct in the workplace, 3 years, okay? So it's the same. Does the length reflect the level of wrongdoing, what horrible person the defendant was? Well, if you have a case where someone's life or their business was completely ruined by defamation, that's 1 year. You could have the family of a person who was murdered. They still are subject to the ordinary wrongful death statute of limitations. That's 3 years. So it's not about the severity of the injury, and it's not about the degree of wrongdoing that's involved. So how do you get these limits? Well, let's compare some of the other statute of limitations we have in Maryland that are actually longer. Default of a lease contract, 4 years. Lawsuits over promissory notes, 12 years. Contracts under seal, 12 years. Lawsuits over recovery of land, 20 years. Are those more serious disputes than the ones I talked about? Absolutely no, they're not. But the difference in setting a statute of limitations depends on the evidence involved with the claim. When you have claims that are based on sort of hard papers, land, those types of claims typically will have longer statute of limitations because they're not going anywhere. That's there. The witnesses aren't dying. It's all about the paper or the land. It's not going anywhere. So you could have very lengthy statute of limitations in those sorts of situations. But where you have in your typical, case, especially cases involving negligence, standards of care, those types of claims are highly dependent on witnesses, on records, on memories, and on the context. And in those types of cases, we have relatively short statute of limitations, but we do make sure that if someone is injured and they're a child, we don't start that clock until someone becomes an adult. And there are some areas where the legislature has provided additional time to sue, where there may be some delay in connecting an injury to an event to an injury or death that occurred. We talked about medical liability actions before, and we provide there 3 years of discovery up to 5 years, okay? For toxic torque actions, we provide 10 years of a person's death or 3 years of learning the exposure was linked to the death, whichever is shorter. So in those areas, there's still a finite statute of limitations, but it does provide some flexibility in a longer period of time given the type of situations you have there. And that's, what you've done in Maryland over time with the statute of limitations for childhood sexual abuse. I think the chairman went through the history during his introductory remarks to the hearing. So I won't go through this again. It has basically been extended in 2003 and 2017, and the previous extensions have all applied prospectively, and it now stands, as you know, at 20 years of turning 18. There's also provision that allows for a case to be brought 3 years after a perpetrator's conviction. Looks like part of my slide got cut off here. So what are the concerns with eliminating a statute of limitations or reviving a time-barred claim? I mean, first, eliminating a statute of limitations entirely sets, a troubling precedent. I mean, any type of civil action, I don't know of any other action in Maryland law where there is just no statute of limitations in the civil context. It doesn't matter how tragic the injury or horrific the conduct. No plaintiff's lawyer wants to tell an injured person who's seeking help that the time is too late to sue, right? But as we've discussed, there's needs for finite statute of limitations, a real key core element of the justice system that helps us reach accurate decisions about liability, and they also provide some predictability to businesses and nonprofits that at some point in time their liability exposure is going to end. The second concern that organizations that are members of ACHR would have is the retroactivity of the legislation, the reviver. That type of provision significantly exacerbates the concerns that we already have with the bill. At least when a statute of limitations is prospectively expanded or even eliminated. Organizations can make rational decisions and appropriate decisions to reduce their liability exposure and to be prepared if someday they are sued. Let me give you some examples. I mean, if a business is a nonprofit and knows that Maryland has eliminated its statute of limitations for a particular claim going forward, they can do things like adopt a record retention policy that will keep their records forever instead of discarding them. They can meticulously document whatever steps they take in whatever area is subject to the extreme liability exposure, how they made hiring decisions, how they made disciplinary decisions and termination decisions, what trainings did they provide, any reports of misconduct, how it met the best practices at the time, and keep those records, again, forever. A person or a business understanding that liability exposure is going to go on forever can simply decide, no thank you. They can simply decide, I'm not going to go into that line of business. I'm not going to provide youth services. I'm not going to operate a private school. I don't want to be involved in that because I could wake up one day at 90 years old and face someone serving me with a lawsuit. They may decide that it's just too risky of a business and not to get involved in it. Or they may be able or try to get substantial additional insurance to make sure they're adequately covering that risk going forward. In a similar vein, if you're a business and you're thinking of acquiring another, I've been sometimes involved where one business is doing due diligence to decide whether it's going to purchase another business, and they look back and they think, what are the possible liabilities? And when they'll do that, they'll look back at the statute of limitations period, and they'll think about where the potential lawsuits could be, and they'll decide, I'm going to buy that business, I'm not going to buy that business. They can't make that decision if there's a retroactive. Prospectively, they can understand, okay, we've got to look all the way back before we get involved with this business. We don't want to be associated with that business if there was something back in 1930 that happened. So when a legislature, extends or eliminates a statute of limitations retroactively, organizations, individuals, they don't have these choices anymore. I mean, if you're an organization like the YMCA and you're sued for an employee that allegedly committed abuse 50 years ago, when the perpetrator died the year before the lawsuit was filed, when the employment records were discarded with ordinary practices 7 years ago, and the few staff members that are still alive have little or no memory of either person involved, you face an extraordinary burden. I mean, you could also have a dentist or a doctor who takes over the family medical practice and then is served with a revived lawsuit alleging that that person's father or grandfather abused the patient at some point. This might have occurred before the current owner of the practice was born or even went to medical school. And you could have a small business that provided exercise or sports programs to elementary schools, and they're sued because an employee who worked at the organization for a few months is accused of abuse 30 years earlier. And the person who founded and owned and managed the business at the time has long retired or moved away, and the current owners have no knowledge of what occurred. In addition to these practical problems, you also have the scenario of reviving time-barred claims being during a particular window of time, as is being considered, resulting in a sudden surge of unexpected litigation that, even if an organization did have some level of records and witnesses and institutional knowledge, which they probably won't, to defend themselves, they will have the challenge of suddenly having these decades-old claims all at once. Finally, the slippery slope. Over time, has been discussed to some degree earlier today, there's going to be, many sympathetic plaintiffs. There's going to be other important causes. There are long-standing unremedied injuries that are out there, aside from this. And there's going to always be unpopular industries and defendants. And as I said, it's never easy to tell someone their time to sue has passed. Allowing the revival of time-barred claims here is inevitably going to lead to future calls to permit claims alleging injuries based on conduct that occurred decades ago, other types of conduct, to go forward in Maryland courts. And we've already seen, the American Tort Reform Association has already seen, these revivers laws expand. Legislation that, first we've seen them expand in the sexual abuse area. Legislation in New York and has moved from childhood sexual abuse to having a reviver for adult claims. California also did a reviver recently for adult claims and threw in added employment claims. Vermont started with childhood sexual abuse, then expanded it to physical abuse, and now has a bill considering expanding it to emotional abuse. We also have seen, going way back and continuing now, efforts to revive time-barred claims in other areas. Maine, a few years ago, had a proposal to double their statute of limitations for product liability claims and apply it retroactively. That was not passed. Oregon considered reviving time-barred asbestos claims in a 2-year window. Also not passed. New York last October revived certain environmental claims involving emerging contaminants. We've also seen proposals getting at sort of those other unremedied injuries and social issues proposed. In California, there was a bill that would have revived actions involving climate change against businesses. Another California bill provided for reviving claims alleging certain types of human rights abuses that would have applied retroactively going back 115 years. I'm not sure where they got the 115 precisely. So while most of these proposals have failed to gain support, if Maryland does move forward with this path of reviving time-barred claims, you're going to see more of these types of proposals in other areas. And ADRA's concern is that, going in this direction, where tort claims just inevitably involve tragic injuries and some involve serious misconduct, is going to set a precedent that will come up again and again. How have other states responded on this issue? Well, over the past 2 decades or so, state legislatures, they've considered hundreds of bills to lengthen the statute of limitations for civil claims alleging injuries for childhood sexual abuse. Most legislatures have, like Maryland has, responded by prospectively increasing the statute of limitations, even if a bill started out with a more extreme approach. They've mostly retained finite limits and decided not to revive time-barred claims for both the reasons that I discussed earlier, the policy reasons, and also for constitutional reasons, which we'll talk about a little bit more in a moment. And these are just some recent examples I have on the screen here. Maryland's period is right in the middle of where some of these states went in setting an age prospectively for increasing the statute of limitations in the last couple of years. By my count, 24 states and the District of Columbia have revived time-barred claims since 2002. I think Ms. Robb's tally is 27, maybe a little bit higher because she may be including some non-state jurisdictions like Guam and other places. But I've got 24 states in D.C. But what's most important here, and then I think maybe overlooked, is that most of these laws had very significant constraints on what claims were actually revived. They were not open-ended, anyone could sue any time back revivers. Some of them were, most of them weren't. You've got first, as Ms. Robb mentioned, there were 3 states that revived claims for perpetrators only. Those are Massachusetts, Georgia, and Rhode Island. You've also got states that limited the reviver to claims that an organization had actual knowledge of the abuse or committed some level of criminal misconduct. I'll give you some examples of that. Oregon, for example, limited its reviver to claims against a perpetrator or an organization that knowingly allowed, permitted, or encouraged the abuse. Utah was perpetrators and those who would be criminally responsible for the abuse. West Virginia, perpetrators and a person or entity that aided, abetted, or concealed the abuse. Arizona required clear and convincing evidence, as a standard higher than preponderance of the evidence for revived claims, that a person actually knew of any misconduct and created an unreasonable risk of sexual conduct with a minor by an employee, a volunteer, or a representative, and prohibited punitive damages in those cases. Okay, so those are some examples, and I think they go along with what we often hear when we talk about this topic and often hear in hearings, that, as Ms. Robb said earlier, let's make sure that we have liability for the institutions that conceal them, for the perpetrators and the institutions that conceal them. That's what these states did, the perpetrators and the institutions that conceal them. There are other states that had required for revived claims gross negligence. Delaware, Hawaii, Vermont were those 3 states. Now, you have in your current law, I believe it's after 7 years of majority, there's a gross negligence standard for claims, something kind of similar, which I believe the proposed legislation would do away with. And there were quite a few states that enacted these new finite statutes of limitations, lengthy ones, and said they apply retroactively. So in those states, it's not a reviver any time back. It's a reviver so long as it's within the new statute of limitations, whatever that is. So that does place some limits on how far claims can go back. 2 states, and Michigan's sort of a strange example, have a look back that cuts off at a certain year. The Michigan reviver was very narrowly limited to basically victims, minor victims of Larry Nassar, a physician, abuse by a physician during a certain time period. And then, there is one state that has limited damages for revived claims. That was Colorado. We may disagree on whether that's called a reviver or not. It was a new cause of action for childhood sexual abuse that really was just a codification of the old cause of action. But because their constitutional law said they couldn't revive time-barred claims, they went down another route in calling it a new cause of action. It's really just a reviver. But they did have limits in that bill of $350,000 for public entities and $500,000 for private entities, which a court could raise, at least for private entities, I believe, to $1 million in certain situations. There's also been, in most states, a debate over whether public entities should be included, are included. If the bill, typically, in states, the law tends to be that if the bill doesn't specifically include public entities, or specifically amend its States Tort Claims Act notice provision or other limitations, then the bill is typically construed by the courts as not taking away the sovereign immunity of the state. So there usually needs to be a provision in there that says that it applies explicitly to public entities. California, initially, when they passed their first reviver in 2002, did not include public entities. There was $1.2 billion of liability on the church, but the claims against public schools didn't happen. So California, years later, revisited that and now has included public entities in the reviver. So, the sum up of where the law stands across the country is that most states have gone the prospective route when they're expanding statutes of limitations. A few have had open-ended revivers. California, New York, New Jersey, Minnesota are examples. But about 2/3 of the 24 states that have enacted some form of reviver had at least some safeguards that are absent from at least House Bill 1. You may be considering them for your Senate version, but they're not present in the House version. And, of this list, as I'll talk about in a moment, there are going to be, there's already been one, but there's going to be more that are found unconstitutional. And I'll talk about that in a second here. Okay. So let me start on the constitutional questions by starting from a national, sort of general perspective, and then talk a little bit more about Maryland. The minority approach in the states, and it's the approach that is currently followed by the U.S. Supreme Court for federal cases, is that retroactive criminal laws are unconstitutional, retroactive revivers of prosecutions are unconstitutional, but the legislature can revive time-barred claims if it at least explicitly states its intent to do so in the legislation. That's the minority approach. It's about 1/3 of states have firm case law supporting that approach and have upheld these types of laws. The Supreme Court in those same decisions has said we disfavor retroactive litigation. We see the concerns and problems with it, and states can provide through their own state constitutions additional safeguards if they choose, and many of them do. The majority approach, and there are some states where it's not clear, but the majority approach is that once a statute of limitations has run, it's over, the time period has expired, a defendant then has a vested right that can't be taken away by subsequent legislation. Let me just say, this has nothing to do with the statute of repose stuff that we were talking about earlier. This is just about statutes of limitations, okay? And courts reach the same result when they apply a specific state constitutional provision. Some have provisions that say you can't do retrospective legislation, period. Whether they apply due process safeguards, a remedies clause, or some other provision. This is the generally where they end up, the majority of states. Here's just, a sample of 7 state Supreme Courts that have affirmed that this is the majority approach. There are more. I'm just providing, in their own words, don't take my word for it. This is what, states across the country in every region have said that this is the majority approach. And that should be in your materials. The most recent decision, came out of Utah. And, in that state, the state Supreme Court was asked to rule on the constitutionality of the reviver I mentioned earlier, which was limited to perpetrators and criminally responsible parties. And in that case, 2020, they looked at that 2016 law and said that, we followed the majority approach. We're still following it. And we have enormous sympathy for the victims of child sex abuse, but our oath is support, obey, and defend the Constitution. And that's what they did in that case. Right now, I should say, by my count, 15 of the 24 states that have revived time-barred claims did so since 2019. So these are all real recent laws. Most of these are really recent laws. The older ones, California, Connecticut, have been found constitutional, some of them. But the newer ones, the bulk of them, are just now working their way up through the appellate courts. And there haven't been decisions on them specifically. There are challenges pending right now in 5 states: Colorado, Louisiana, North Carolina, New York, and Rhode Island. And my assessment of those states' laws is that in at least 4 of those states, it's very likely that those statutes will be invalidated as unconstitutional. The wild card is New York, which is the only state in the country that takes what they call a functional approach to determining whether a statute of limitations is reviver is constitutional, meaning that they will, to some degree, balance the interests of plaintiffs and defendants, and they'll look to whether there was an absolute need to revive the time-barred claims. They don't, as in most other states, simply say vested right or not a vested right, and that's what most states do. So New York's a little bit of a wild card, but the other 4 states, their constitutional law, like Maryland, indicates that reviver of time-barred claims is unconstitutional. Just this week, we filed an amicus brief, ATRA, in the Colorado case, and just came across my desk yesterday, the amicus brief that was filed by the public school system, a group of organizations representing public schools in that state. And they said, one of our members just, got hit with a claim, a notice of abuse claim from the early 1980s. And we've searched around, and we can't even figure out, was the alleged perpetrator, were they employed? We don't even know if there was an employee, let alone whether that person had some interaction with the claimant. That 30-year-old teacher would be 80 years old, over 80 years old today, if they are still alive. And if we even look back, because the door is open to even older claims, the chances of getting witnesses or documents are really remote. And by the way, our record retention policy was always based on the statute of limitations and our limits on resources. We couldn't store records, school records forever, employment records forever. At some time, we ran out of space and we had to get rid of them, so we don't have the records. So let me talk about a little Maryland's constitutional law. And we've talked about this earlier. The chairman mentioned some of the cases. You've got, several cases, I'd say, that clearly indicate the Zadua versus Comcast case, that number one, retroactively abolishing an accrued cause of action deprives a plaintiff of a vested right, and similarly, retroactively creating a cause of action or reviving a barred cause of action also violates a vested right. And, I think this is a point I missed earlier, I wanted to make, is that the principle of vested rights in the statute of limitations context doesn't just protect defendants. In the majority of states, it's a principle that protects the plaintiffs and the defendants. Why? Because, if this legislature decided, let's say this legislature decided that the 20-year period, maybe 10 years from now, decides the 20-year period has caused problems, 20 years of 18, and we want to move back and make it 5 years. You can't do that retroactively because it would take away the claims of all those people who are in that time frame who thought they had the ability to sue. And that's how it protects plaintiffs. You can't retroactively shrink a statute of limitations and take away people's claims. On the other side of the equation is that in the majority of states, the principle applies equally to defendants. You can't retroactively revive a cause of action once it's expired. And then you have the 2011 case in Doe versus Roe, which specifically involved the statute for childhood sexual abuse when it was made 7 years. And the question in that case was whether that statute could apply to extend the period for a person whose claim had not expired. And And the answer was yes. The answer is yes, and we don't, we agree with that. States can, and it is across the country the rule, that a legislature can retroactively extend the statute of limitations for a person who still has a viable claim. Once it expires, vested right. Before it expires, not a vested right. You can expand that statute of limitations, whether it's from 7 years to 20 years or 20 years to indefinitely, so long as that person hasn't lost, the time hasn't run on that particular claim. And that's what the court said in Doe versus Roe, and they said we would be faced with a different situation entirely had the plaintiff's claim been barred on the earlier 3-year limitations period before the 7-year period. The statute of repose. There's a lot of discussion of this issue. I honestly think it's a distraction. Because as I've said before, if we just look at this from the perspective of a statute of limitations, the majority rule across the country is it's already unconstitutional to provide for time-barred claims. If we look at Maryland case law, the indications all say that it is likely to be found unconstitutional to revive time-barred claims. So we've had a lot of discussion about who knew what and who knew when and who put it in and who realized that these paragraphs were in a 2-page bill were in there. From my perspective and from the analysis of the statute of limitations, it really doesn't matter because it's already unconstitutional. The statute of repose that was included in the 2000 legislation provides some additional likelihood on top of what I already think is a significant likelihood that the Supreme Court, as it's now called, will find it unconstitutional. Is it, I'll jump forward here. Is it is it a statute of repose or a statute of limitations that you've enacted? I mean, the Anderson case is the key case to look at, as was explained earlier. I'm real familiar with that case because it was the only time in my career that I've actually was representing a plaintiff in a medical malpractice case against the federal government when that case was pending before the high court. And my case would have been dismissed had the court found that that was a statute of repose. So I was rooting for it to be a statute of limitations. But the way the court reached that result was, number one, it looks at the trigger, right? Is the trigger in the statute the injury or not? Is some other period of time? Number two, is the period that's in there subject to, did the legislature say that there's no tolling, or did they not? Which tolling is something that is associated with a statute of limitations, as was discussed earlier. And did the legislature say it was meant to be repose, a statute of repose, or didn't it? And in the case of the medical malpractice statute of limitations, it was still triggered by an injury, the claim. There was no indication that their ordinary principles of tolling could not apply. And the legislature said nothing about repose. And that's where the court, came down on the side of limitations and people that I was representing at that time. Now, if you contrast that with the 2017 legislation, the trigger isn't the injury, it's turning 18, 20 years of 18. The statutory language says in no event, which would suggest no tolling. And the uncodified portion of the bill says it's a statute of repose. So, we can argue whether it's repose or not. As I said earlier, I think it's unconstitutional as a statute of limitations. But it does appear to me, at least, to be a statute of repose. And what's the difference there? I mean, what are we arguing about? I mean, the Maryland Court of Appeals has said over and over and over again that a statute of repose creates a vested right to be free from suit that is absolute, and you can't change it. So that does provide that additional assurance that you could not change the law after it's enacted for those folks who fell in the statute of repose. The decisions on the statute of limitations reviver, while there was the Smith case that was mentioned earlier, the case looking at the earlier statute of limitations, some would say that that's dicta, that the court said that you can extend a period that hasn't run, but you can extend the period after it's run, because in that case, the period hadn't run. But the court was very clear in what it said, as it was in the Dua case, about the vested rights running both ways. So there's still, because there has been a square decision on that precise issue in recent years from the Maryland Court of Appeals, some degree of question, is it absolutely certain that how the court will rule on a statute of limitations? And I think that's probably whoever put it in there into that bill, or however it got there, was probably thinking, we're okay with extending the statute of limitations once again to a significantly longer period, but we don't want to keep revisiting this reviver issue anymore. And that's probably why it was put in there. Obviously, that seems to have backfired since we're continuing to talk about this today. We also have, and if you haven't seen them, you should take a look at them, 4 opinions out of the state AG's office on the question of constitutionality. For the reasons I just stated, the author of those opinions hedged a bit when talking about if it's a statute of limitations, whether it's constitutional or not, called it a possibility it would be unconstitutional in one letter. In another, used a double negative, saying it would most likely be found unconstitutional as a, I'm looking at the wrong quote. Well, use a double negative to say it's probably not, it may not be unconstitutional. But the most recent decisions when looking at the statute of repose language made very clear that she found that this was a statute of repose and that this would violate vested rights and be found unconstitutional. So what are the alternatives? If more time is needed beyond the 20 years of majority, of course, you can always extend that time prospectively. From ATRA's perspective, there should always be, for any type of civil claim, a finite statute of limitations. ATRA, does not support reviving time-barred claims of any kind, but, if the legislature is committed to going down that path and doing that approach, the legislature should consider, the types of constraints that other states have used when reviving time-barred claims. They should make sure that this is not going to apply unequally, both to people based on where they were abused and who abused them. It should apply equally to public and private entities. And I think if you are going to move forward with a reviver, I think you need to be prepared for the likelihood that the law is going to lead to unnecessary litigation and provide false hope to survivors who file the lawsuits, as the Supreme Court of Maryland is more likely than not going to find this provision unconstitutional. So thank you again for your time in considering this very difficult subject, and I would be pleased to take any questions you have.
Thank you. You had mentioned Utah, and I forget the second state that you talked about, a statute that was put in place so that entities or organizations that essentially acted in a manner to, stop a suit from going forward. They had some bad act. I'm curious what your position was on that type of legislation when it was passed in Utah and the other states.
Well, I think what you're referring to, Utah, what they had passed there was the reviver applied to perpetrators and those who committed criminal criminal misconduct. There were several other states that took a similar approach that I mentioned. Those were Oregon, Arizona, and West Virginia. They either limited it to an organization that is shown to have had actual knowledge of the abuse and not responded appropriately, or limited it to criminal-type behavior, aiding or abetting in the abuse, hiding the abuse. Some knowing intentional misconduct, as opposed to what you're considering here, which is bare negligence. I mean, bare negligence is what you should have known, what you should have done. It doesn't mean necessarily you knew anything or did anything.
Right, so what was your position on that?
So our position is that if you are going to go down the path of revivers, that's a more defensible approach. Atcher is not going to support any type of reviver.
Okay,
but that's a more
all I wanted to
defensible
know.
approach.
Thank
Yeah.
you.
Thank you, Mr. Silverman. Just quickly, you mentioned a June 2021 Attorney General opinion. I don't think I've seen that. Did we have that? Oh, it was yours? Oh, okay. I can get it from him. Thank you.
Thanks for coming out today. I just have two quick questions. One is, on slide 5, you referenced within 3 years of the conviction, the perpetrator's conviction. Is that in conflict with the 20 years that's currently there? Or if the conviction, say, were to be determined later, like at 25 years, after the age of 18, does the 3 years begin at that time?
That's an additional type of action.
So it could be outside the 20
It could be
years?
outside, yes.
Okay.
But I believe it's only likely against the perpetrator. I don't know if that will
Okay.
permit a claim against an
So it would
organization.
not, okay.
Yeah.
And then, you referenced, I believe on slide 6, about the discovery of negligence. You referenced, does the negligence require a group or company to know that this person was committing these acts, or are they responsible regardless? And I referenced, like, for example, like Jerry Sandusky at Penn State. They were made aware of it. There was things that happened. They chose not to handle it in an appropriate fashion for whatever reasons. So do they have to, because negligence is it's not it's a gray area. It's not a hard defined term to be able to say that negligence, and to have some negligence, you would think they would have to have had some knowledge about it.
It's a new or should have known standard. So knowledge isn't necessarily required. Certainly a case would be bolstered by having knowledge, if they were shown knowledge, but it's not required. You can look back at, should they have had hiring practices or screening practices or in place that might have detected someone, for example.
Okay, thanks.
All right, seeing no more questions from the committee, I have a couple of questions I'll follow up with you offline. But really appreciate you being here, and thank you for staying to the end, and thank you for the information, which is accessible through the website. Thank you all very much. With that, that'll conclude our briefing for the day. See you all tomorrow.